Indeed, Dr. Ayine's decisions are in furtherance of the research agenda of the AMISTY. The material facts will bear this out. Dr. Ayine was sworn in as Attorney General on Wednesday, the 2nd January 2025. On Friday, 24 January 2025, the court filed a notice of abandonment of their bill by the state and Republic of South Forcing and 2 others. On Tuesday, 28 January 2025, we withdrew the case against Dr. Sinopuli and 2 others, resulting in the complete whitewash of their crimes by an acquittal and discharge through the back door. On 29 January 2025, we entered another withdrawal in Republic versus Kusuamofo and another, again resulting in an acquittal and discharge of the accused. On 30 January 2025, Dr. Ayine withdrew 2 different cases against Dr. Johnson Pandit Isema, resulting in his acquittal and discharge in one and a discharge in the other. There were more withdrawals and no prosecution to be entered by the NDC government through the Attorney General in the subsequent days. Indeed, all through the trend of one day, one withdrawal was the occurrence of weekends. Ladies and gentlemen, this development irresistibly points to only one conclusion: a calculated, preconceived ploy on the part of the NDC to wipe out all criminal cases pending against its leading members and officials of the John Mahama government and clear them of wrongdoing not by the court but through their Attorney General. Remarkably, there is no precedent for this kind of conduct in the fourth department. Throughout the 2 8-year terms of the NPP government, no Attorney General appointed by either President Kufuor or President Kufuor withdrew criminal charges or filed non-prosecuted in cases involving leading members of the NPP or senior members of the government. At the time the NPP assumed office in 2017, all the cases filed by the SWA NDC government against the ministers of the Kufuor government and other appointees have been contested fully in the court and won. We secured acquittals through the court and not by resorting to delayed tactics in the hope that the Kufuor appointed Attorney General would come and withdraw the cases and procure an acquittal. I speak from experience as I personally conducted some of the cases. Other lawyers within our ranks, including my colleague Deputy Attorney General, also handle same. I must state that it is clearly unprecedented for an Attorney General to hold a press conference and subject his predecessor in office to abuses and pending falsehood in the manner displayed by Dr.Dominic. I'm constrained to set the record straight, to unveil the half-truths and manipulation of facts for what many Ghanaians to decipher the true intentions of the NDC government acting through the current Attorney General and withdrawing charges against leading members of the NDC. One, it is necessary to indicate at the outset that the decision to charge a person with a criminal offense, especially in the high-profile cases, an issue which has serious implications for the public purse, involved a prosecutorial discretion exercise pursuant to painstaking investigations conducted by duly authorized investigative authorities of state, inquiries and extensive deliberations by career prosecutors in the office of the Attorney General, who indeed proceeded to conduct the cases themselves. I continue to be grateful for the advice I received from the hard-working attorneys at the AG's office, investigators and my able deputies, Mr. Afronitaa and Mr. Nasnomadapa, on the cases we personally initiated in office, and the many others that have been commenced by my distinguished predecessor, Madame Gloria, before the proof, which will continue. We cherish the robust discussions and debates we had whilst professionally moving forward with each of those cases. The nation would note that Dr. Ayine and other leading figures in the NDC and the government of the day were counseled in many of the cases he has discontinued. I say that indeed it is not uncommon for defense counsel and Dr. Ayine and other NDC personalities were looking at the same set of facts to come to different conclusions, informed by their varying understandings of law and, of course, the undeniable political considerations involved. However, I dare say that in taking decisions as monumental as drawing those cases, the only consideration has to be in the national interest and not that of the defense counsel. The analysis I make of the reasons advanced by Dr. Ayine will expose the questionable intent behind the withdrawal of the criminal cases. Dr. Ayine's unfounded allegation insinuating unethical conduct on my part in the conduct of the ambulance trial, the public versus Council 2000 and and two others is highly disingenuous and rather unfortunately recaps a series of falsehoods persistently published by foot soldiers of the NDC and other uninformed members of society. I must say that I find it quite ironical for Dr. Ayine, who is the subject of disciplinary proceedings for professional misconduct, still pending at the General Legal Council, filed by the Honorable former Chief Justice himself, to accuse me of unethical conduct. In the interest of the nation, the case of professional misconduct pending against Dr. Ayine at the General Legal Council should have been determined before the parliamentary assessment of his suitability or otherwise for the high office of the Attorney General and Minister for Justice of the Republic. The facts related to allegation by Dr. Ayine that I interfered with an accused person in the ambulance case are well within the public domain and have been adumbrated in court proceedings. The record shows that there has been a judicial determination of that unfounded allegation frequently made by foot soldiers of the NDC and other uninformed. Shockingly, Dr. Ayine, the current Attorney General, ignored this fundamental fact in his 10-page press statement and over an hour conference with the media for the simple reason that he knew that this allegation had been flatly debunked by the court when same was put to strict scrutiny. If you would recall, the accused person in the ambulance trial filed an application for mistrial, hanging same on the alleged interference with one of the accused persons. On 6 June 2024, the High Court quorum or sitting through or presided over by the Chief Justice Efia Sewa Saribotri dismissed the application. You will all remember the learned Justice of the Court for Appeal, who serves as an additional High Court judge, said that she had listened to the tape in question about 10 times and found nothing to warrant a mistrial. Specifically, she stated at page 24 of her ruling, and I quote, after listening to a conversation between the third accused and A1, the issue of whether the Attorney General actually told A3 to implicate A1 is not borne out by the evidence on Exhibit CAF2. These words were uttered by A3 at about minutes 09 to 10, minutes 10. In the same vein, the declaration that A3 was innocent and was going through ordeal, but was being asked to help make the case with the better, was not made by the Attorney General, but was made by A3, to which the Attorney General responded at minutes 10, second 20. And I quote, I am not asking you to help me at minutes 10, second 30. The statement that you and I have been meeting at my cousin's place at minutes 10:45, etc., were quite closely together with A3's alleged attack of conscience did not proceed from the mouth of the Attorney General. End of quote. The judge proceeded to state at page 32 of her ruling that the third accused, and I quote, the third accused by any stretch of imagination is saying to be the one. The third accused by any stretch of imagination cannot be seen to be the one procuring new evidence or cowed by conversation. End of quote. In the face of this clear judicial pronouncement of no wrongdoing as to warrant a mistrial, it completely defies logic and good reason why the Honorable Attorney of Ghana will say to the public that I was capable of what he describes as a disgraceful and unethical conduct in the ambulance trial. Ghanaians want to know rather how the current Attorney General, Dr.Dominic, will deal with the complaint of professional misconduct pending at the Legal Council against him, but no less the person than the former Chief Justice of the Republic. Ladies and gentlemen, in a chilling twist, the nation head Dr. Ayine confessing to speaking with lawyers for the defense and engaging them on the cases that were pending against leading members of the NDC before exercising his discretion to file non prosequi or withdraw the charges. He indicated that in Republic versus Jachukwesi, the lawyer for the accused expressed an inclination to go on and prove the innocence of his client, and therefore he decided to enter non prosequi. Respectfully, what this betrays clearly is that the exercise of Dr. Ayine's discretion to consider the prosecution of cases or not is informed principally by the disposition of counsel for the accused in cases that the Republic is prosecuting against their clients. Thus, if counsel for the accused is in a position to strongly defend the interests of his client in court, the Attorney General of the Republic will not enter non prosequi. Where the counsel for the accused are not convinced of the likelihood of a success of their defense in court, Dr. Ayine will immediately enter a non prosequi if the prosecution has not closed the case. and a withdrawal if the prosecution has closed this case, so that an acquittal and discharge will be secured. As I will show in an examination of each of the specific cases cited in Ayine's press statement, the Honorable Attorney General quite comprehensively relied solely on the case for the defense before exercising his discretion to discontinue the actions. He did not engage in any meaningful consultation with the prosecution's division of the Office of Attorney General before instructing the filing of the withdrawals and not prosecuted in the cases against senior members of the John Mahama government and other leading members of the NDC. The dates of filing of the said processes buttress the assertion I made, and I've referenced them already. I challenge Dr. Ayine to show any memorandum presented to you by the prosecution division of the Office of Attorney General advising or indeed expressing a view on the consultation, discontinuation, or termination, as he calls it, of any of the criminal cases in question. I can say without any fear of contradiction that there is none. He should also show evidence of consultations on any of the charges he held with the Director of Public Prosecution, the DPP, before he continued the cases. You can be assured he cannot produce any. Listening to Dr. Ayine, one gets a distinct and chilling confirmation that he relied solely on the version of the facts as presented by counsel for the accused, as well as their erroneous views of the law on the salary matters in question. It is for this reason that the claims of alleged defects in the various charges only re-echo positions attributed by the defense counsel throughout the various proceedings. In effect, Dr. Ayine came to narrate to the Ghanaian public on Wednesday the perspective of defense counsel, the charges their clients have been charged with. The media will notice that for each of the cases, the explanations of the Attorney General for the withdrawal were only a rehash of arguments already reported in the media as having been made in the courtroom by counsel for the defense. Is that a reasonable manner of the exercise of the Attorney General's discretion to enter a withdrawal of criminal cases? I ask. The people of Ghana should be very scared if we have an Attorney General whose prime consideration for the discontinuation of criminal cases involving the loss of billions of Ghana cedis is the position of defense lawyers on charges preferred against their clients rather than the interest of the Republic in the prosecution of crime. Even more scary and bizarre is the claim of Dr. Ayine that he did not consult the former president, John-Dramani Mahama, before taking the monumental decisions to discontinue the criminal cases. The cases involve the loss of colossal sums of taxpayers' money and some related to the banking sector crisis which affected the Ghanaian economy. The people of Ghana should indeed be extremely concerned and afraid by the vesting of prosecutorial authority in a person who can discontinue the prosecution of such important and high-profile cases without discussing with the President of the Republic and members of the Cabinet. Even defense counsel, according to him, the consultant, how much more the President? Ladies and gentlemen, we ought to ask ourselves, is it true that Dr. Ayine did not consult the President or his Cabinet about the decision to discontinue the various criminal proceedings? A careful examination of the facts shows that this claim is palpably untrue. The nation has not forgotten the loud claim by President John Mahama and the NDC that the MPP rather was responsible for the collapse of the banking sector crisis. And that on assuming power, the John Mahama government will restore all the banking licenses which were revoked. The withdrawal of the cases in question is only the first step of the clearing or whitewashing process of those whose acts led to the crisis that plagued the banking sector. Ghanaians are certainly more discerning than the NDC and Dr. Ayine think. I proceed to examine Dr. Ayine's reasons for withdrawing some of the criminal cases Dr. Ayine mentioned in his first statement. And I find generally that all his explanations are laden with contradictions and inconsistencies and betray the questionable motives for his actions. First is the Republic versus Keziatufosin and another case. The first reason assigned by the Attorney General for the discontinuance of the appeal is ethical and professional, since, according to him, he was deeply involved in the conduct of his defense, as the defense of Dr. Atufosin. He could not, according to him, in all good conscience, continue the conduct of the appeal. This explanation is a sham, as the Attorney General's constitutional authority under Article 88.4 of the Constitution is exercised by himself or, and I quote, any other person authorized by him in accordance with any law. Pursuant to this, the Criminal and Other Offences Procedure Act 1960 Act 30 permits attorneys of the Office of Attorney General and other persons, including even private legal practitioners, to whom the Attorney General may delegate his powers through an executive instrument enacted pursuant to Act 30 to prosecute. Thus, the fact that he, Dr. Ayine, found himself in a conflict of interest situation did not imply that the entire appeal had to be abandoned. Dr. Ayine characterizes the prosecution of the ambulance case as a political witch hunt. I wholly disagree. The facts show that vehicles purporting to be ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. In the absence of any request by the Ministry of Health, and at the time that the period for supply of the ambulances and the contract had even lapsed, Dr. Kisira Tuforsen, by letters dated 7th and 14th August 2014, instructed the Bank of Ghana and the Consular Secretary General to issue letters of credit, which was the agreed means of payment for the vehicles under the agreement. The letters of credit were consequently established on 18th August 2014. BC General Trading Limited, the suppliers to the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on receipt of the letters of credit. When the vehicles arrived, they were not of the kind specified in the contract and had serious defects with every material part of the vehicles, which rendered them unfit to be described as ambulances. Indeed, a John Mahama appointed Minister for Health at the time, Dr. Ayine, described the vehicles as ordinary vans, not fit for purpose. The defects were so irremediable that from the time the vehicles started arriving in December 2014 to January 2017, when the SR Jomama administration left office, they could not be converted into ambulances. To date, they cannot be converted into ambulances, and the Jomama government is back in power. I am on the honest view